Welcome to the BYU Copyright and Trademark Symposium debate. I think this is maybe the fourth year that I've had the chance to direct traffic during the debate. It's always a really fun assignment. As Peter said, my name is Julie Rose, and I host Top of Mind, which is a daily news interview show. We're heard on Sirius XM satellite radio, channel 143. We're also streaming on byuradio.org, or where you can get us wherever you get your podcasts. We are live every afternoon from 4 until 6 p.m. Eastern. So, to the debate. Let me introduce the topic just briefly for those of you who may not be quite up to speed on what this issue is that we're debating today. Perhaps you've used the Wayback Machine to dig through past versions of websites online. Well, the nonprofit that does that archive, the Wayback Machine, also has a book archiving project called the Open Library, and they collect books, they scan them, and they loan those digital copies free to the public. Authors and publishers do not love this because if a library wants to loan a digital copy to someone, it can buy a digital copy of the book with a special license for that purpose. But a legal theory known as controlled digital lending has emerged, which basically says, if you have a hard copy of a book in your library, you can loan one digitized copy of that book instead, but not both of them at the same time, and definitely not multiple digital copies of that one book that you have. And that is how the Open Library was operating until the pandemic. Physical libraries shut down, wait lists to check out ebooks from libraries exploded. So the Open Library turned itself into the National Emergency Library. What's the difference? No more wait lists to get one digital copy of that one physical book in the library's collection. The National Emergency Library would loan out as many digital copies of that one book as people wanted to borrow. The publishing company sued very quickly, calling it willful mass copyright infringement. And a few weeks later, the Open Library dropped its emergency lending policies. They asked for the lawsuit to be dropped. It has not been dropped. And the debate remains as well over the underlying theory of controlled digital lending. Courts have never ruled on it, and experts are divided on whether it violates current copyright law. Should libraries be allowed to circulate digital copies of physical works in their collections? That is the topic of our debate today. Each side will present their best argument, and you, the audience, will decide who wins. In order to do that, we need you to register with us where you stand on the issue right now, before you've heard the arguments. So please take the poll that should be appearing on your screen right now. We'll give you a couple of seconds to do that. Today's debate proposition is libraries should be allowed to circulate digitized copies of physical works in their collections through controlled digital lending. All right, as you can see there, it looks like a lot of people agree with today's debate proposition. The way we will determine the winner is which side changes the most minds to their point of view. So this is not a guaranteed win for the pro side of the argument. Both sides will have the opportunity to persuade people to their side of this, and we'll see how that turns out at the end. But let's now meet our debaters. Arguing for the proposition, we have Dave Hansen. He is the Associate University Librarian for Research, Collections, and Scholarly Communications, as well as Lead Copyright and Information Policy Officer at Duke University. He is co-author of a widely distributed white paper on controlled digital lending of library books. Dave Hansen, welcome. It's good to have you with us.
Thank you, Julie.
And arguing against the proposition on the other side of this debate, we're pleased to have Devlin Hartline. He is a legal fellow at the Hudson Institute's Forum for Intellectual Property in Washington, D.C. Devlin, welcome to you.
All right, thank you. It looks like I have my work cut out for me.
I'm sure you're up to the task. A couple of quick things about how the format will go here. Each side will have 5 minutes to deliver an opening statement. I'll be keeping track of the time. We'll then have a short rebuttal from each side and an opportunity for the debaters to ask each other questions. And then we'll take some time taking questions from the audience. And as Peter mentioned before, we're going to use the Q&A function, not the chat function of this Zoom webinar. So please submit your questions at any time. You're welcome to do so in the Q&A function of the webinar. And you can also vote up questions with the little thumbs up by clicking on that underneath each question that you would like to second, and we will give priority to questions that have received the most support from the audience. I may also ask some questions if we are short on questions from the audience. And then we'll have some brief closing statements from Devlin and Dave, and then we'll come back to you and we'll ask you the question again. We'll compare the vote tallies, and the side that has changed the most minds over the course of this debate will be the winner. Again, today's debate proposition is this: libraries should be allowed to circulate digitized copies of physical works in their collections through controlled digital lending. Dave Hansen, arguing for the proposition, will speak first. Dave, you have 5 minutes.
Thanks, Julie. And thank you, Peter, and all the organizers for inviting me. So I had planned to start off with just a basic definition of controlled digital lending, but I think Julie covered the bases so well, we can just move on beyond that. I think, the critical pieces to understand with controlled digital lending, the idea behind it is it's a pathway and a methodology through which libraries can take items in their physical collections, and in this case, we're talking specifically about controlled digital lending of library collections of books, and how they can use that process to essentially allow for digital access on a one-to-one ratio. And so in the white paper where we talk about controlled digital lending, we use a term, an owned to loaned ratio. The idea is the library has purchased a book and is making the intellectual content of that book available on roughly the same terms in terms of user access as it had in the past, just in a different medium, and in this case, digital. So a few things I did want to clear up just at the outset and kind of define and hopefully narrow what we're talking about here. One is, Julie mentioned the Internet Archive and the Internet Archive lawsuit and the National Emergency Library, which is a issue and a project that was opened up during the height of the pandemic. But I think it's important to recognize that the National Emergency Library really goes beyond what we're talking about with controlled digital lending. It may have other legal justifications behind it, but has a separate rationale. So the other piece is that the question that or the proposition asks whether libraries should be allowed to do controlled digital lending. And I think what we're really debating then is a policy question. And if we're debating a policy question on copyright, I think really that goes to the heart of what are the overarching goals of our copyright system. I think we can all look at and recognize that the constitutional origin of our copyright system says that it's for the promotion of the progress of science and the useful arts, which is implemented through granting exclusive rights to authors for limited times. And I think the Supreme Court has given us some nice guidance in a number of different instances on how that works. One case in particular I think is useful to look to is Sony versus Universal, which is a case well in the past that dealt with another technological disruption, VCRs. In that case, the Supreme Court said that the limited scope of the copyright holder's statutory monopoly, like the limited copyright duration, reflects a balance of competing claims upon the public interest. Creative work is to be encouraged and rewarded, but private motivation must ultimately serve the cause of broad public availability of literature, music, and the other arts. I went on to say that when technological change has rendered its literal terms ambiguous, the Copyright Act must be construed in light of that basic purpose. So libraries lending books has always been an essential part of that balance. Libraries actually predate the copyright system that we have. And library lending has been the backdrop of the markets that have developed, that the statutory copyright systems that we have for the last 200 years. And the default rule in our copyright system has been that libraries can provide meaningful, beneficial access one at a time for users of books that the library has bought. When libraries do that, they provide value to the rights holders by paying for those books upfront, but they also provide that broad public availability to encourage learning and discovery and those underlying goals of the Copyright Act. So the major problem that we face, and what CDL is attempting to resolve now, is that lending print books doesn't cut it anymore. We've seen from COVID and the access and travel restrictions over the last couple of years that physical access is far from possible for everyone. And in addition, evolving societal norms, for example, what it means to serve people with mobility or other travel issues who can't get into a library, as well as generational issues. We have this generation of, if it isn't online, it doesn't exist. So what CDL aims to do is open up the stores of books that libraries have been buying for decades, for centuries. They essentially sit locked away right now for most users. And CDL equalizes those access and benefits to the public of those materials. It also supports the market by limiting meaningful, economically relevant engagement with the book on the same terms that we have always done with physical books. One person using a book at a time, regardless of the format. Thank you.
Thank you, Dave. That was right on time. 7 seconds to spare. All right, we'll now hear Devin Hartline arguing against the proposition. Devin, you have 5 minutes.
All right. Good morning, everyone. It's great to be here virtually with you all today. Thanks to Peter, Michaela, and the rest of the BYU team for putting together this wonderful conference. And I'm especially grateful to Julie for moderating and to Dave for taking up the other side. It should be fun. The proposition that we're addressing today is that libraries are allowed to circulate digitized copies of the physical works in their collections through the mechanism of controlled digital lending, or CDL. In other words, we're here to talk about the latest iteration of Napster, but this time it at least comes with the fig leaf of a library. Let's start with common ground. There's no doubt that libraries are important. They foster knowledge, education, and truth. They contain centuries of information and history, and they provide readers with books, the copyrighted works that are central to the topic at hand. Under the CDL theory, there's no permission needed to make the digital copies in the first place. In fact, even the library's friends can make the copies, nor is there permission needed to share them publicly. The CDL theory instead posits that all of these things are perfectly legal, and presumably they have been for decades, though people are just now starting to notice. Of course, people who follow these things know that these issues are nothing new. Digital for sale, mass digitization, orphan works have been discussed, studied, and litigated for years. And no doubt these issues will be debated for years to come as Congress decides what to do about them. And yes, it is Congress that should step in to clear things up. But ultimately, the CDL theory is really just the CDL fantasy. It's an example of wishful thinking by those who continue the long line of supposed do-gooders who have figured out yet another way to give away other people's work for free. Indeed, it seems that the very purpose of CDL is to gain in the courts what they have been unable to gain in Congress. The CDL white paper primarily argues that it's non-infringing under the first sale and fair use doctrines. It's a bit wishy-washy on whether first sale can actually carry the weight, and it instead tries to import exhaustion into the principles of its fair use analysis, but the amalgamation doesn't work, and the whole is no greater than the sum of its parts. It's interesting to point out the significant exceptions that are not being claimed. Section 108 provides statutory exceptions for libraries to make and distribute copies, even digital ones. That sounds like something that might support CDL, right? No, Section 108 was hammered out after years of studies, debates, hearings, and drafts. You know, the way laws are usually developed through the compromises of the democratic process. But Section 108 does not allow digital copies to be shared beyond the physical premises of the libraries, and that's just no good for CDL. Another statute that proponents of CDL largely ignores is Section 110, the Teach Act, which creates exceptions for the use of digital copies in distance learning, one of the purported goals of CDL. Of course, there are limitations there, and so that's no good for the CDL proponents either. They want everything right now for free. Why is the CDL white paper so cautious in claiming first sale? Because it's not first sale, it's not even close. First sale applies to the distribution of a particular physical copy, and transmitting a work online results in the creation of several new copies. It's not the alienation of a physical good. The fair use argument is just a rehash of the same arguments that were raised to support the defendants in the Authors Guild's lawsuits against HathiTrust and Google Books. The Second Circuit in those cases blessed the scanning of millions of books in order to create a searchable database that returned page numbers, frequency of terms used, and even snippets of text. But both cases were very clear that providing the entire work itself is a very different story. It's not fair use. It's a simple fact that no court has ever found that giving away entire works for free online without additional comment or criticism constitutes fair use. And finally, I'd be remiss if I didn't discuss how CDL hurts authors and publishers, the heart of the literary system that creates the books we love in the first place. The rights of authors are not some minor inconvenience to be routed around. They are the lifeblood without which our shared culture would shrivel up and die on the vine. We should not be figuring out new ways to rob authors of a living. We should be doing everything we can to make sure that they thrive in the digital age. The CDL theory would jettison the hard-fought balance that's reflected in the Copyright Act. And why? Because change is hard, but it's a battle worth having if we're to consider and accommodate the divergent interests of the various stakeholders. And if we want more books, we need to make sure that authors get paid. It's as simple as that. Thank you.
Thank you, Devlin Hartline. All right, we now have time for a 3-minute rebuttal from each side. Dave Hansen, you'll go first.
Thanks, Julie. So first, one point I want to emphasize is the very limited nature of controlled digital lending. So controlled digital lending is very much tied to a market transaction that happened earlier in the life of a particular copyrighted work. So a library acquires a book, they exchanged money for that, or someone did at some point in the process and acquired it. The next step that happens under the controlled digital lending approach is that that book is made available one at a time to a user. So it is actually very limited in terms of the number of users who can get access. The potential reach is limited by what libraries have already invested in those books. And so it's very much different than the kind of Napster, Grokster situation where you have essentially unlimited copies proliferating online. So that I think is a really critical piece. And actually, I think that's reflected in the Internet Archive's approach, which is when they were doing controlled digital lending and the pandemic hit, we were hitting up against an issue of large lines, people unable to demand exceeding the quantity of materials that they had available based on that 1-to-1 owned to owned ratio. So that's one point. The other that I want to emphasize here is that we're really talking about library use. And I realize that there are other kind of abstractions of the controlled digital lending theory that we identify in the white paper. You could imagine similar ideas of a broader kind of digital first sale doctrine. But one of the things that we take a lot of time and talk through in that white paper is the special significance of libraries in the copyright system. So Devlin pointed out a couple of the other places where the copyright system strongly favors library uses that are aimed for promoting learning and discovery. Section 108, for example, that's an interesting one to look at because it allows libraries to make copies of works, including in a couple of provisions, full text copies of works. And in many ways, they're actually more liberal than what we are proposing with controlled digital lending. So section 108H, for example, allows a library to make essentially unlimited numbers of copies of works that are in the last 20 years of their copyright protection, as long as you go through the steps of that particular part of the statute, looking at, for example, commercial availability. Section 108E does a very similar thing. And so, when we look at those provisions, they indicate something about congressional intent. And what they're saying there is that there are very specific areas where Congress has said, we want to make sure that this is super clear, that with the technology and the systems that we have in place, these kinds of uses are going to be absolutely protected. But none of that discounts what's available to libraries under Section 107 under fair use. And so that's essentially where this argument in terms of application under existing law lives.
Thank you. Dave Hansen, thank you. Devlin Hartline, you have 3 minutes.
All right, thanks. So, you know, I agree with Dave that this is a policy question, at least the way that the proposition is framed, but it's obviously also a legal question. And because as Dave's white paper goes through the legal arguments for it, first sale and fair use, you know, Dave points out that libraries buy books. Yes, they do. And it's a wonderful thing. But buying a book and loaning out a book in the physical world is completely different than making copies of the book, digital copies, and then getting into the ebook market. The ebook market is a separate market than physical books. And so there are separate considerations. There's only so many times that a person can physically go to the library and check out a book and bring it home, and copies deteriorate over time. And so all of these things with first sale, you know, arose in the physical context where we were worried about people being able to alienate their chattel, you know, their physical goods. The digital world is totally different. Once you make a digital copy, it's a perfect copy of the book, right? And it can be shared with other people. And now you've got a piracy problem. Just things are very different. And so that's why these things have been debated for like at least 2 decades. And so this is my primary problem is CDL is like, well, we don't have to worry about all these debates that have been going on and, you know, congressional hearings and draft legislation and all these things. Let's just call it all fair use and be done with it. Dave points out that CDL is limited, and that's nice. Like, for example, it uses DRM or TPMs to protect people from copying it further. That's great, but it's also totally ironic that they're infringing in the first place, and then they publicly distribute these copies, and then they try and stop those people from infringing. But that takes the eyes off of what's actually happening. And the library is making the copy. What justifies that? And then the library is distributing those copies. What justifies that? Who cares about what maybe would happen downstream? We're talking about what happens in the very beginning. And so I would, I've got 1 minute left, thanks. And so, if we're gonna talk about Internet Archive, I think, generally they tried to follow the CDL approach, but again, obviously they didn't follow it with the National Emergency Library. But what interests me is not the NEL, it's like whether CDL itself is infringing. And I think it clearly is. And I'll turn it back to you, Julie.
Very good. Thank you. All right, we'll now have the opportunity for each of you to ask a question of your opponent. We'll do this once, and then if we want to do one more, we can, and you'll each have 3 minutes to respond to that question. So Dave Hansen, arguing for the proposition, is there a question you'd like to ask Devlin Hartline?
Yes, thanks. So a major part of the rationale for controlled digital lending is that libraries have already paid for the copy that they're lending, but are seeking to essentially shift access to a new and more meaningful format for users. So without CDL, does that mean that libraries and their users are forever beholden to the format in which they acquired their copy? We have Laserdiscs, microfilm, VHS, Betamax, 8-track, zip drives. Are we stuck? Or must they find a way to license and pay again to access to that same content?
Thank you. Devlin Hartline, you have 3 minutes.
All right, now that's a great question. So let's talk about what is copyright. Copyright is a permission-based system. That's the idea, right? We give authors exclusive rights. They have the right to exclude other people. And yes, we can sit around and think about all the great ways that we could use their property for the public good, but that's not how copyright works. The public good is promoted by enforcing those rights, by giving authors and publishers and whoever happens to own the copyright the ability to decide for themselves, how are we going to release this stuff? So you may look in the stacks and say, there's a whole bunch of great works there. And you know what, we could just digitize them and put them online for free and we'll call it fair use. And again, this debate is going on for a couple decades, right? These are not new ideas. They have been debated, and the Congress has held hearings. There have been all kinds of Copyright Office reports about it. Numerous stakeholders are coming together, and they've been discussing these things. And it seems like eventually we probably will have some kind of mass digitization or orphan works legislation, but that's the way it should happen. It should happen through the compromises of the democratic process. It's not for one side to say, I'm going to call it fair use. Let's just scan all those books and make the entire thing available online for free, because that would be a great thing to do. We have to look at the other side of the equation. Who's going to write these books if you can just get them all online for free, right? Who's going to publish these books if they're all online for free? We have to look at the entire creative ecosystem that creates these works in the first place, and we have to support the authors so they can earn a living to write the books that are on the shelves, right? And so that's my main concern. I agree that access is great. I'm not saying libraries are bad. I love libraries. Libraries are great, but this is beyond library. And I called it like Napster because in my mind, it basically is. It's like, here's a great thing that we can do with other people's property. So let's just do it. And we'll say, well, we have the public good on our side. And that's not the way it works. You have to hammer these things out. You have to have all the various stakeholders come together. And everybody's going to have to, there's going to be give and take, right? Not everybody's going to get everything that they want. And it's not going to be this like beautiful thing that some people have in their minds. That's just not how the real world works. And so that's my answer, is that it's a great idea. And I don't disagree that it could be good, but it has to be done in the right way. And it has to respect the rights of everybody involved.
Thank you. All right, Devlin Hartline, you can think fast now and ask a question of your opponent, Dave Hansen.
All right, I'm going to put Dave on the spot just because I can. And so we talked about the Internet Archive's National Emergency Library. And so for people who don't know, they basically got rid of the controls in the controlled digital lending theory. And so I'm going to put Dave on the spot and ask him that whether he thinks that the National Emergency Library was illegal or not. And so he mentioned in his opening comments that there were other legal theories that might justify it. None come to mind for me. And if you look at the lawsuit that's currently going on with the publishers, it seems like they're going to rely on fair use and first sale, the same things that we're already talking about. So Dave, what do you think about the NEO?
Dave, you have 3 minutes.
Thanks, Devlin. So first, I want to flag again, I believe that the National Emergency Library was not following the principles of controlled digital lending we outlined and kind of the core of this debate. And the principal reason is because access was opened up to go beyond what was tied to the physical holdings, right? So the idea that like only one person could look at a thing at a time or look at a particular copy at a time. In terms of, does Internet Archive have an argument for a National Emergency Library that goes beyond controlled digital lending, essentially allowing for broader access? I think that's really the crux of the case. And I think that some of the arguments in its favor are really tied to the extraordinary nature of the pandemic and the extraordinarily short period of time with which they opened it. And essentially it gets down to how much should fair use encapsulate and deal with the short-term shocks to our system, and how much can fair use accommodate the underlying goals of copyright to promote the progress of science and the useful arts, to keep the engine of learning moving. And I think that its primary application had been in schools, right? And so we saw that lots of schools, lots of libraries, in fact, I know lots of libraries at universities implemented a version of CDL and in the midst of the pandemic, and the National Emergency Library was aiming to push a little bit beyond that and make sure that no student who needed access to a book was stopped short of getting it. I think a couple of factors in its favor are, one, the market was essentially failed at that moment in time. If you remember back, it was very, very difficult to get books shipped. In fact, even a semester later, even in the fall, I encountered students at my university who could not get their textbooks in time for the start of the semester. The global supply chain had fallen apart. And so I think the question is, does fair use help to resolve that market failure? And I think there's a very strong case there for the National Emergency Library because of that. I think the other thing is where those particular books were targeted and used. And I think that given the educational target for it, that's really right at the core of what copyright is designed to promote, learning and discovery. And so I think that those are two really strong points in its favor. It's a very different argument and a very different situation than I think we've ever seen before. And extraordinary circumstances require extraordinary responses. And I think that the key question there is, does the copyright system have a mechanism built in to absorb and deal with those shocks, or does it not? I would like to think that our copyright system is flexible enough that it would allow for those kinds of applications.
Thank you, Dave. All right, we do have a lot of questions brewing from the audience, but I'll give you both one more chance to ask a question directly of your opponent, and we'll keep those responses to 1.5 minutes. So Dave Hansen, do you have a question for Devlin that you'd like him to answer?
So I do have a question. So one of the criticisms of CDL, as we've defined it at the outset and defined in the white paper, is that it can be applied to all types of books, fiction, nonfiction, and kind of regardless of market circumstance. So my question to you is, are there more limited categories of books, such as orphan works or books that are out of print, or works that are just not available on the ebook marketplace, for which you think CDL would be an appropriate solution?
The short answer is no, because you're digitizing entire works and you're making them publicly available. It's not for sale, it's not fair use. And so you mentioned, in your answer to the last question, you talked about how there was a market failure with the pandemic. And in my experience, I didn't see that. I saw publishers opening up their collections and making textbooks and other educational materials available for free online. I saw scientific publishers making their things available online so people could study the coronavirus itself. I just don't see that there was some kind of a narrow target with NEL that was focused only on education. And I think that's the problem. Is there were all kinds of things available in the NEL that weren't educational whatsoever. These are entertainment books that have nothing to do with education. It's just a fig leaf to say that's what it is. And so there's just no case law that says there's some kind of emergency superpower for fair use in the time of a pandemic. There's just nothing supports that notion. And to get to your question, I'm not denying there's a problem with orphan works. I'm not denying there are benefits to mass digitization. Again, these things have been studied, and I think we need to do it in the democratic process. And that's the answer. The answer isn't just calling it fair use.
Great. It looks like we'll be coming back to that topic in the audience questions in a moment. Devlin Hartline, do you have a question that you'd like Dave to try to answer in 1 minute and 30 seconds?
Yes, I do. Okay, so I wonder what Dave would say to an individual author who is barely making ends meet during the pandemic. They're not able to go to book signings. They're not able to have these speaking engagements. And even the bookstores where they would do those things are closing down. And I wonder what he would say if they came to them and said, hey, look, I make $20,000 a year. I'm not a rich guy. And so is your CDL theory taking the interest of these authors to heart?
I actually think that small authors and small publishers are one of the virtues of controlled digital lending. So in that, when CDL is allowed, if CDL is a applicable theory that libraries can use to lend their books, what it does is it incentivizes libraries to continue to spend money on a broad and diverse collection. So it says, when you buy that book, it's going to have a future. It's going to have a use for your users way out into the future. That's really different from the licensing market that we have today for ebooks. Without it, we have a really decreasing motivation to continue to engage with those small publishers and those small authors. For a lot of libraries, given the challenges in licensing, the market consolidation amongst the major publishers and the costs that come with dealing with that, what we're forced into is a situation where if your book isn't available through Overdrive, if it's not available through a handful of platforms, it basically doesn't exist for libraries and the library market. And so what CDL does is it says we can reach outside of that really structured licensing market, and we can continue to invest in those small authors and those small publishers and buy their books and make them available in a very limited way to our users.
Thank you. All right. And to that point, we're going to now switch over to the questions from the audience. Just a note for the audience, we're doing this in the Q&A. It looks like you all got that memo, so good work. And also, if you hit the thumbs up, then it will move questions up. I know that a lot of this has been happening during the conversation, and we've addressed some of these issues. So you're welcome to go in there and remove your thumbs up. So that'll move some of these down if you feel like you no longer want to spend the next 20 minutes on that as part of our conversation. So the top voted question at this point goes right in line with what you were just discussing, and Devlin, I'll address it to you. Literally thousands of titles from the 1930s through 2010, including many Pulitzer and other prize winners, are not digitized and will never be digitized by publishers due to perceived lack of market and are in danger of being lost in physical format. Shouldn't these be allowed via CDL? There is no monetary loss to anyone. And then the author adds, oh, it just went away for me here. That if it's not in a digital form, then it doesn't exist. Devlin, go ahead.
Well, and that's a great question, and it's probably a better question for Dave because he's the librarian, right? But Section 108 has provisions that allow for the digitization of works in order to preserve them for the very problem that this question is addressing, is what about these works? What 108 doesn't allow you to do is then take those copies and just share them online with anybody who wants them, right? And so why? Because copyright recognizes that it's up to the copyright owner to decide what to do with their works on their own terms. That's the bargain that's envisioned in the Constitution, and that's what we have in the Copyright Act. It's about the author's choice. It's not about us saying, well, we don't really like what you're doing with your work, so we're just going to do something with it anyway. You can do that, but guess what? You have to get Congress to change the law.
And Devlin, let me just follow up with this other question. Is there any evidence that CDL, controlled digital lending, harms author payments?
I'm not an empiricist. You're asking the wrong guy that question. It seems self-evident to me that if you're giving something away for free, then it's going to cannibalize the market of those who are trying to sell access to it. That's just like pretty basic logic. Is there any evidence? I don't know. Again, I'm not an empiricist, so I apologize. I don't have a great answer for that one. It's a great question, though.
Dave Hansen, let me interject with a question of my own for you. Is there any role for Congress in clarifying this at this point? Or do you believe that controlled digital lending is legal and self-evidently so under existing copyright laws and policies?
I always think that there's a role for Congress. I think, there's been a long running debate about Section 108 and revisions there. And I think that it's definitely appropriate for Congress to look at modifications to Section 108. I also think that work on controlled digital lending could be welcome. That's not to say that I don't think it's allowed under current law. Fair use does a lot that isn't explicitly recognized in some of the other very specific limitations and exceptions in copyright law. And I think that what congressional action could do is clarify and provide certainty and essentially a safe harbor for folks operating in this space. But that doesn't mean that it should take anything away from the bigger and broader principles that fair use is designed to address. So sure, I think that it's totally appropriate to have some specific congressional action, but that's sort of the history of how copyright has developed since 1976 or before, is that we've had this backstop, this underlying provision or doctrine of fair use that allows for broad flexibility, and Congress all the time has come in and provided with very specific safe harbors. I think a really great example of that is Section 121 of the Copyright Act, for example, which is a provision where they came in and said, making copies of works for blind users, we think that that's a really important policy objective, and we're going to put some framework around that so that there's a safe, predictable way for folks to approach this where they know that congressional policy is identifying these very particular ways. That's not to say that fair use can't reach that same conclusion, but it helps everybody along to have that very explicit safe harbor.
Devlin, do you want to add a comment?
Yeah, no, I agree that fair use does a lot, but it doesn't do what CDL is saying it has to do, right? You can look at the Hathi Trust and the Google Books cases, because that's the most accurate thing that we have a statement on this issue at all, right? And what do they say in those cases? Okay, yeah, giving out snippets, giving out information about the books, that's okay. But giving out the entire books, no, that's not okay. Those cases were pretty clear that they would have gone the other way if that was the case. And on the Section 121, yeah, I totally agree. Fair use is a backstop to whatever is in that statute. And if you look at I think it was the Hasty Trust case that looked at that issue. And what did the court say? Well, look, there's really no market for these blind people. And so there's going to be no market harm. But that's not the case here with CDL, right? There's totally a market for ebooks. There's a very vibrant market for ebooks, and this is in direct competition with it. So it's just a different issue altogether.
Devlin, are you more open to controlled digital lending when we're talking about books that are older than 20 years old? We're talking about books that are not available in ebook or digitized form. Or
there's no like sliding scale that says the older the book, then the more it's fair use. So which fair use factor would that come under? I mean, I guess maybe the fourth is where Dave would argue it. I'm not really sure, but I don't see how that changes the analysis. If we don't know who the author is, then that's an orphan works problem, and Congress needs to solve that. And if we do know who the author is, well, guess what? The author gets to decide. That's the whole idea of copyright.
And so a question from an anonymous attendee that's gotten quite a bit of support. What do publishers propose should happen to books once they are no longer profitable? Should they just be thrown in the trash and disappear from the historical record? Doesn't CDL solve a pretty serious market failure? Devlin Hartline?
Well, again, this is what we have Section 108 for. And you can preserve books even in digital form, especially books that are deteriorating and falling apart. That's why we have these things, as Dave well knows. What we don't have them for is so we can put them online in some version of Napster where everybody can just download them for free.
So people should be able to come and see those digitized works within the confines of the physical building.
Yeah, I believe, yeah, that's what 108 allows. Yeah, and if you want to change it.
Yeah, so I mean, I totally understand that response. And I think one of the underlying questions there that I'd like to probe a little bit more is, how is that serving the underlying goals of the copyright system? How is that helping feed into those incentives that it's supposed to provide if the publishers have essentially said, this thing is not even economically worth it for us to deal with the licensing issue, which happens all of the time. And for us, I mean, my library, we have around 8 million volumes, and the vast majority of those, the ebook licensing market has just never developed. And to me, that's a pretty strong signal that there's no market there, that the publishers, either the rights are too entangled, they're orphan works, or it's just not worth it to deal with it. And so if those works have essentially been economically abandoned, how does it serve the underlying purpose of the Copyright Act to prohibit libraries, for instance, from allowing for more liberal access than just what you get when you're physically required to come into the building?
Devlin, there's a question here from the audience. A lot of people appear to be librarians and seem to have a bit of a bias, which we knew from the beginning here. Libraries, so this question is about interlibrary loan. Libraries generate and distribute in a controlled manner copyrighted material all the time in producing copies of periodical articles for sharing via interlibrary loan. This seems to be a well-established and widely accepted practice. How does that practice relate to or even provide support for controlled digital lending? I guess the question initially to you, Devlin, is, do you think that interlibrary loan in the fashion just described there is also a violation of copyright law?
Well, again, this is probably a better question for Dave because he's a librarian. But my understanding is that 108 actually applies to interlibrary loans. It's in the statute. And why is it there? Because all the different groups came together and hammered it out and made compromises, and the way that democracy normally works. And so I don't think that's a problem as long as it's is what's provided in Section 108.
Dave, is that true?
So Section 108 does deal with interlibrary loan. It has some specific provisions around systematic copying. I think it's important to recognize, though, that interlibrary loan long predates Section 108. If you go back as early as in 1935, there was this gentleman's agreement, this sort of roughly structured agreement between publishers and librarians. And since then, interlibrary loan and reproduction, and for the purposes of facilitating ILL, has just been an accepted underlying part of the market. So what you get in Section 108 in terms of addressing interlibrary loan is some very specific provisions that allow for reproduction and essentially unfettered reuse of those copies. So I mentioned that before, Section 108D and E, copies made for the benefit of users. And those are really interesting to look at and compare to what we're talking about with controlled digital lending, because they place essentially no limits on what those users can do with those copies once they're in their hands. So with CDL, we place all these strings on it. We say, we're going to loan you this copy, but we're putting DRM on it so that you can't reproduce it and go distribute it out on the internet so that it can't proliferate. Section 108 doesn't place any restrictions like that. And it allows users to do what they will with the copies that we hand over to them.
A question here from Tucker Taylor. As a librarian, I often cannot license electronic books for my students because the publisher does not offer a license to libraries, essentially holding the electronic copy hostage, especially considering the health concerns many students have during a pandemic. This isn't reasonable. So the question then, let's turn that into a question. And Devlin, I'll let you go first. In a situation where an electronic copy is simply not available for license to a library, do you blame them for doing CDL instead, making their own digital copy?
Of course I blame them. If it's not available, it's not available. Look, I get it. Everybody wants this stuff to all be online and available to everybody. And that sounds great in theory, but we have to look at, these are markets, right? People have economic rights. They can choose to digitize things that are 100 years old, or they can choose not to, and it's up to them. And so, I mean, from what I've seen, there are a lot of older works that are getting digitized when they realize that, you know, maybe there's a market for this work, and so we should put it out there. But again, this is the copyright system. The copyright system isn't all about access. It's about respecting the rights of the copyright owner to determine the ways in which these works are distributed to the public.
Dave Hansen, how can this line of thinking be limited to print works and not include other legacy media collections held in libraries if controlled lending is available?
I think that, you know, similar principles definitely could be applied to other formats. I mean, I raised earlier, we have lots of other formats that we're essentially trapped into. And I think that this same rationale could easily apply to those. The white paper that we wrote, we tried to limit it to the facts of the situation of print books and the market for print books. And so it was really tailored to applying fair use to that situation. But you see this all over, and it's not limited to the format of the book. We're in a time period when you know, we have rapidly changing norms about and expectations about access to materials. And we're dealing with a legacy of formats that have essentially locked in content into those formats, in some cases not available in any other way. There really is no alternative to get access. And so, you know, when your 8-track player, when the last 8-track player was made, you know, as librarians, we're starting to tick down the clock of like, when can we still buy parts for those things? Same thing for VHS, same thing for laser discs. And that's really problematic, I think, for meeting that constitutional objective of promoting the progress of science and the useful arts, if we're going to say, well, that content just has to be abandoned. And if the players for it aren't made anymore, we just have to move on and leave that aside. We can't digitize, we can't make that more broadly available because of a format limitation.
Devlin Hartline, do you want to respond or add to that?
Sorry, I wasn't thinking of a response. I was waiting for the next question.
Excellent. I do have another question, and it's going to be for Dave. But let me just, there has been a question in the comments here asking for a bit of clarification as people are starting to think about how they're going to vote and whether their mind has been changed. There is a question here about the proposition. Libraries should be allowed to circulate digitized copies of physical works in their collections through controlled digital lending. We have Adam Ellsworth here asking, are we saying that that should be allowed, or are we saying that it's legal? He says here, I think Devlin has convinced me that CDL would likely lose in court based on US code, but I still think that it should be allowed. And so my question to the two of you before we wrap up here in about 10 minutes is, can we agree that the proposition is saying both it should be and it is today legal without any congressional changes? Dave, is that what you've been arguing for? That not only should this be the way libraries can function, but that it also is
Well, I think both are true. As I said when I first started my opening, that I think we're essentially talking about a policy question here of whether this ought to be allowed. I do think that current law fulfills that ought and allows for it under fair use. But I think the essence of the question that we're debating is not so much whether it's digital first sale or Section 109 or Section 107 that allows this, but whether as a policy matter, this is something that libraries ought to be allowed to do.
Devlin Hartline, are you comfortable with that interpretation of the proposition
Yeah.
as people begin to vote? If they have been convinced that
Sure.
this probably would not survive in court, then they likely should vote against the proposition.
Oh yeah, no, and I took it to mean both things, right? Should it legally be allowed? Absolutely, it's going to fail. Should it like aspirationally be allowed? That's totally debatable. That's why we're here.
Okay, very good. Hopefully that clarifies for some people when they get ready to vote here in a moment. All right, question for Dave. How does controlled digital lending address the issue of scanning, copying the physical work in order to create the digital copy in the first place? It seems the theory hinges on that being within the rights of purchasing a hard copy. That is, CDL seems to hang on the theory that digitizing is a legitimate copy of the physical work. And that's something I've been wondering. If I go buy a book, I don't have the legal right to digitize that and then give that to somebody else. Where does the right to make that digital copy initially come from for the library?
Yeah, so great question. So first, I'd say, if we're thinking in the fair use context of what does fair use allow, there are lots of cases that talk about making digitized copies for an ultimate purpose, a sort of downstream use, right? So I think great examples are the Google Books and the HathiTrust cases, where in those cases, the libraries or Google made full text copies, and they did it for the furtherance of that ultimate objective, in those cases of allowing for access to the blind or allowing for search and indexing uses. And so, so the rationale has to sort of trace back from that of like, what is your ultimate purpose that you're aiming for here and how is it serving it? So that's one piece of it. The other piece of it is from a library standpoint, libraries digitize books in whole all of the time. For preservation purposes, for making sure that we have backup copies. In fact, one of the kind of key acronyms in the preservation industry is LOCKSS, which stands for Lots of Copies Keep Stuff Safe. That's sort of standard practice. And so when we are making those those scans underlying, that's among the legitimate purposes that we have in creating those copies that then are held in a repository, for which the argument is then we're lending out on this one-to-one basis out to users.
Devlin, do you have a comment?
Oh yeah, several. So yeah, when the libraries make the preservation copies, this is allowed under 108. That's how they're able to do it. And so if you read the CDL white paper, it totally glosses over how these digital copies are made in the first place. It says, start with a legally acquired copy. Okay, well, there's the problem, right? You have a physical book, you scan it into digital form, and they're not claiming that Section 108 allows them to do this. Why? Because 108 doesn't allow you to just share it with anybody on the internet. And so that's the problem. The other problem is that it's conflating what the library does, right? The library makes the copy, that's copyright infringement, and then it distributes the copy or displays it publicly. That's also copyright infringement. And it says, well, don't look at that stuff. Look what happens with the user, right? The user gets this book and maybe they make fair use of it. They quote it in some research paper that they're doing. And that's great if that's fair use, but we're talking about what happens in the beginning. What gives them the right to make these digital copies? The answer is nothing.
Dave Hansen?
Yeah, so a couple of things. One is when libraries do digitization for preservation purposes, I know at least in my library and others who I work with, very rarely are we relying primarily or even at all on Section 108. We're looking to the broader set of rights that we use under fair use. And that's the principal analysis that we use for that. If you look at the HathiTrust case, I think it's really interesting that there was a Section 108 question in there. And the way that the court handled that was they said, well, that's fine. but you still have access to fair use, and fair use is the thing that that case really focused on. So, so I think that's sort of a conceptual thing about how 108 applies. It's not a limitation on what libraries can do. It's a very specific situation that Congress has recognized needs very special, a very special, essentially safe harbor for libraries, but nothing limits libraries from also using fair use as the underlying basis for that digitization. I think the second thing there is, I talked a bit about this downstream use and how fair use allows us to digitize to enable that downstream use. The argument is there that what we're talking about here is a method of access that has very minimal and essentially the same impact on the market as libraries lending out free books in physical format. And so if that's the rationale, that sort of flows back to making that initial copy. So when we say a lawfully made copy, what we're talking about is, did the library acquire the original physical copy in a lawful way? Did they pay for it? And in essence, the policy question that we're asking here is, when you bought that copy, what do you get for it? What does the library get for that in terms of beneficial access for its users out into the future?
Devlin, I'll give you 1 minute to respond to that, and then we'll transition to closing arguments.
Yeah, so when you buy a physical copy, you own the physical copy. What you don't get is the copyright, the intangible rights to make more copies, right? And so yes, there's a savings clause in Section 108, and yes, you can rely on fair use as a backup. Absolutely, no doubt about that. And I don't even deny that you had asked, Julie, if you buy something, can you digitize it yourself? That's format shifting. The courts are kind of split on that. It's probably, I actually take a broad view of fair use, believe it or not. And I think that probably is fair use. And I would argue that. I have no trouble with that. But it's different once you go to share something, right? So under Sony, I can record over-the-air transmissions on my DVR, and that's fair use. But if I took that recording and tried to sell it to somebody on eBay, well, it's probably not fair use anymore, right? Because now I'm distributing it. And so that changes the nature of the entire reason of why we allow people to copy something in the first place, for personal use.
Great. All right. Thank you to both of you, and for all the comments and questions that came in from the audience. We'll now have our closing statements. Each side will have 5 minutes, and then we'll do our vote. So Devlin Hartline, arguing against the proposition, you will go first. You have 5 minutes.
All right. The goals of CDL are admirable. Who doesn't want to promote the progress of science, as the Constitution puts it? But copyright law has never been about giving away things for free while pretending that that act alone promotes the public good. On the contrary, copyright promotes the public good by granting and protecting exclusive rights in original works of authorship. Copyright recognizes that progress is best achieved by fostering an environment that supports the creation and dissemination of new works, not freeloading that undermines the entire system. The problem with giving everything away for free is that eventually there will be little worth giving away. By design, the copyright system is based on permission. That permission-based system supports the creative ecosystem that brings us the wonderful content that we all enjoy, both in the physical world and online. And this system supports authors who want to charge access for their works in order to put food on their tables, or those who are happy to give it away for free. But CDL thwarts the very engine of free expression by favoring free access over author remuneration. And that's not the copyright bargain, and it is not the law. The Internet Archive, especially its pandemic-born national emergency library that throws out the controlled part of controlled digital lending, it shows us that authors and copyright owners are right to be worried about what CDL is really about. It's really about giving away copyrighted works for free on a scale like we have never seen before. And make no mistake, it will not end with just the distribution of books. The theory will be applied to all kinds of works, movies, sound recordings, video games, with the goal of rendering copyright a nullity. No one doubts that digitization is a laudable goal, and if it's done right, it can even solve the problem of orphan works. But this problem is so complex that only Congress can step in and fix it. There's this weird notion, particularly among copyright skeptics, that anything arguably supporting the public good must be legal. But these arguments downplay the inevitable harms that would result from CDL. And more fundamentally, they misunderstand the ways in which copyright law supports the public good. A central repository of the world's knowledge sounds appealing, but we have to keep focused on the plights of authors and publishers who labor to provide us with that knowledge. And at the end of the day, CDL is just the latest fad in copyright law and policy. It's the latest supposed justification for why we should just outright ignore the rights of copyright owners, full stop. I don't begrudge those who want to share culture far and wide, but I do take issue with those who fail to recognize the critical role that copyright protection provides. I'm also concerned with the notion that some organization can just ignore the legislative process. These are difficult problems that will take years to iron out. Compromises will be made and they will not come easy. The reality is that the emergency of the pandemic has been addressed within the law. Authors and publishers have risen to the occasion to make their works available, whether for educational purposes or for critical research into the coronavirus. The pandemic has changed how many do business, accommodating for the need of socially distancing. And many businesses have gone under, unable to adapt in a profitable way. And these are serious problems, and CDL only exacerbates them. But the ones who have adapted and the ones who have failed, they have not taken copyright law into their own hands. They have not pretended that fair use allows them to do whatever they want with the works of others. They have not made themselves the final arbiter of how the law should work. They haven't pretended that giving away other people's property without permission is somehow an act of charity. No legal construct supports the CDL theory. Exhaustion under the first sale doctrine does not apply because numerous copies are made as works are transmitted over the internet. Fair use does not apply because the use is non-transformative, and it is a direct market substitute that competes with the original. Section 108 creates exceptions for libraries to make and share copies, but they don't want to work to change the law. Section 110 allows for distance learning, but their goal isn't really to educate. They simply want everything to be online right now for free, and that's not good policy. It's certainly not the law. And more importantly, it hurts authors who are already struggling before the pandemic to make ends meet and who are struggling now more than ever. So thanks again to Peter, Michaela, and the rest of the BYU team. And thanks to Julie and Dave.
Thank you, Devlin. All right, Dave Hansen, you have 5 minutes.
My turn. All right. So libraries have always given away things for free. That's how libraries work. We buy a single copy, we lend it out to many users. And that way, libraries are aggregators of market demand. Actually, for large parts of the market, without libraries, that market wouldn't exist. I know that especially, I work in an academic library. When I look at scholarly works, scholarly publications, with print runs of 1, 2, 3, 400 copies, if libraries weren't buying those books, that market would collapse. And so what we do is we buy and then lend out for free. And the essence of the argument against CDL, the essence of the policy argument against CDL is that libraries ought not be able to continue that function in the digital space, and that every use that we make in the digital space must be licensed and provisioned and must follow and have strings attached to it from the rights holders. That has all sorts of problematic implications for what it means to own a work, to what it means to own a copy. And so that argument that libraries have lent for free has been long accepted as part of our copyright system. It's the backdrop for the market that we have today. And the essence of CDL from a public policy standpoint is to say that libraries ought to be able to continue that basic function in the online space. You can argue against that, but I think what you're essentially arguing against is the idea of libraries as an institution. So beyond that, there's this question that I have not really been focused on of, is CDL permissible under current law? And in defense of that, I want to point out a few things. One is controlled digital lending and the application of fair use is not an end run around Congress. CDL is not a solution to the major mass digitization debates that we have had for the last 20 years. The promise, that the glimmer of hope that mass digitization gives us is that we have the technology to provide broad, unfettered, open access to materials all over the globe. We absolutely can do that. And the things that are hanging us up are how to get the rights situation clarified and how to figure out the business model going forward to make such access possible while supporting those who are creating and publishing and disseminating those works. We've seen that in other places. We've seen that dream realized in the scientific publishing community. The fastest growing segment of publishing right now is open access articles. We haven't seen that in the legacy or backlist content that libraries are holding. And so that's the real promise of mass digitization. And I think that that really does need a legislative solution. But what CDL does, just like other applications of fair use before, is it carves off a little piece of that and it says, well, fair use can do some of it. Fair use has been applied in a number of mass digitization contexts when at the outset, what was told is that that's a job for Congress, that's a legislative solution, when fair use actually provides quite a bit of flexibility to keep copyright on track and minimally keeping track with its constitutional objectives. I think the Google Books case is a really great example of that. Google scanned millions of volumes of books and was told that that needed a legislative solution. And it went through the courts and they said, no, actually fair use can accommodate this type of mass digitization for this narrow purpose. We saw the same thing with HathiTrust. And I think that that's really the trajectory that CDL tries to follow, is to carve out this narrow use that is highly respectful of the market and that tries to prevent any unnecessary harm, any harm to the market that goes beyond what libraries already have in that market by lending out copies for free in physical format and making them available to users in formats that are actually meaningful and useful for them today. That impact on the market, surely speeds things up, makes things quicker for folks to access. I think part of the argument there that the Copyright Office and the USPTO and some others have raised is that, well, that market is much more, has much less friction, can move much more freely. But those aspects of the market aren't things that copyright holders get to protect. When it takes time and money for me to ship a book to my user, the copyright holder gets none of that. FedEx does. And so those sorts of frictions certainly are built into the market, but are not part of what the market grants to rights holders. So the essence of my argument from a policy perspective is libraries have always done this. Libraries have lent books out, made them available in meaningful ways to users. What we're trying to do here is find a way to do that in ways that are continuing usefulness for users in formats that they're actually expecting to use them in.
Thank you. Okay, thanks to the both of you. And now the moment of truth. It's time for the audience to vote. We'll give victory to the side whose level of support improved the most during the course of the debate. Please take the poll appearing on your screen. We'll give you about 30 seconds for that. All right, and then I think we're going to see here, they're going to plug in some numbers to show us the change in support levels. And while they're doing that, I would like to thank Dave Hansen of Duke University and Devlin Hartline from the Hudson Institute. Normally we'd be doing a loud round of applause, but I know that the audience has really appreciated your preparation and your your engaging arguments in this case. Well, I don't do very good math, so that's why they do this for us. And I think we're going to see a slide here that will show us where people were at the start of this debate and where they ended up. So beforehand, 75% agreed with the proposition, 9% disagreed, 16% were undecided. We're looking for percent change here. All right, so 60% agreed, a drop of 15%. A lot of people changed their minds, which I believe means that Devlin Hartline, yep, he moved the needle the most. So
I feel like I had the most room to move the needle, but I really appreciate it.
But we saw Dave lose a little. Yeah, he held on to a little less than you were able to gain. So for the purposes of this debate, Devlin Hartline, congratulations.
Well, thank you so much. I really enjoyed it.
And thanks again to the both of you.
Thank you.